Hello, can everyone hear us?
Yes,
I
Nancy.
hear you.
Good, because Tom, when you spoke, there was a reverberation, so I want to make sure that wasn't happening with us. So anyway, so I'm very excited to do a copyright sort of 101 refresher course, which it seems always good to have every couple of years. And I'm really lucky to have Heather Cameron, who will be my color girl. She is, means commentary, and she will be much funnier than me, but let's get started. And we will, I think, hold questions to the end. The first thing I usually talk about when we talk about copyright is sort of understanding some of the boundaries. There's no such thing as international copyright. The internet may have no boundaries, but when I'm talking about copyright, I'm going to be talking about US copyright. And the way it works is that we have international treaties that countries agree that they will join and sign on. So if an author's work from a country that is a member of the treaty is infringed in a particular country, they will protect the rights of that foreign author. So the laws of some countries are different. And when we get into fair use, that's a good example because US is one of the only countries with fair use. Other countries have express exemptions or fair dealing. So I just want that to be an overarching understanding. Next slide. And when I'm talking about the copyright law, I'm talking about our current act that's actually been around since 1978. It's been amended many times. We finally joined the Berne Convention Treaty in 1989. I don't know what took us so long, but it took us a while. And then we had some major revisions in 1998 when we passed the Digital Millennial Copyright Act to try to bring us up into the digital age. And just very recently, I'll talk about it later, we now have a copyright small claims board that started this summer. And when you talk about copyright, I always start with the source. The source of an authority for our laws in our Constitution, where Congress gave the Constitution gave Congress the power to enact laws that are to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and drawings. And the whole purpose of Copyright Act is to have a balance between the economic interests of creators and the public interest in having a broad creative intellectual base of content and other things. So you notice it talks about authors and not users. So really the idea was if authors are protected, that users would benefit. Next slide. And so what does copyright protect? It protects a lot of works. And if you go down the list, literary works actually include software. The works that most members of the DMLA have would be pictorial, graphic, sculptural works, photographs, design works, visual arts, and then audiovisual works are included. You'll note that architectural works are there, but that's really to prevent someone from not creating buildings that look exactly alike. And it allows taking photographs of architectural works from a public place. Next. And copyright doesn't protect everything. There has to be a low level of creativity, and a lot of areas where there's a lot of confusion is graffiti and tattoos. So when you talk about graffiti, graffiti can rise to the level of a work of visual arts because it's a very low level of originality. But often when we look at libraries to determine if there's any kind of protectable work within a photograph, you might make a distinction between essential scribbles that no one work is distinctive and perhaps the tag of a well-known graffiti artist. And Heather may have some comments about how much fun it is to vet images for graffiti.
It's so fun. It's just a pleasure. Just something to think about. We certainly have seen our share of inquiries that have come in about it. And we like to think if we're shooting for the news specifically, we love this AFP photo that's up here on the left to sort of illustrate the concept of here's an actual artist. Ooh, Nancy, I got some feedback. Who's actually creating something in progress. The news story is about that creation, about that specific location in Berlin. And then the stock photo that's on the right, there definitely is some graffiti type, tagging in the background. No one particular tag is standing out more than anything else. Incidental to the photo. In my personal experience working at Getty Images for such a long time, there seems to be a connection. If you want to shoot something that's urban, you have to have graffiti in it or a chain link fence. It's just kind of entertaining, but we like to think about it being sort of incidental and sort of not the focus of the image. And also it's sometimes a great idea to do a stock shoot where you've hired an artist to create some real life looking graffiti for you, but it's not really authentic in a sense where you're not going to get a claim from an artist. You can get a property release from that artist that's working with you for a stock shoot. And then you're covered, your clients are covered. They're not going to get claims, or you have to call Nancy for help, although Nancy loves that. You can call her.
Right. And isn't it generally, if you need an image of a city and make it look authentic, if you take like a long shot down the street where you have multiple works and none of them are in focus, for editorial use, it's much better than if you just put one image in the frame.
Right.
Okay, let's move on. And all right, as a copyright owner, what do you get to control? Because that's the important thing. What belongs to you exclusively? And in the US, we break this down into a reproduction right, which is making a copy, the derivative work right, which is very confusing to everyone. That's when you adapt another work. You take a photograph and you make a painting. The right to distribute publicly is what happens when you offer images online. Public performance is for audiovisual work, and a public display. So an image that's called up on a website would be a public display, and performance is just for digital sound recordings. In Europe, they use other words like exploitation and things like that, but these are the US copyright words. So.
Do you know what I tell customers when I talk to them about this? I just tell them that copyright owners get to be very bossy, and they get to say who does what with their stuff and respect it.
That's what exclusivity means. As I said, derivative works, that's where there's often a lot of confusion about what's an adaptation and what may be a change for fair use. But if you want to adapt a work, for example, you like a stock photo, but you thought maybe it would look better, if perhaps the models were wearing the brand of your client's clothes or something like that, you can license for a derivative work. Isn't that right, Heather?
That's right. Yep, absolutely.
Or if you want to do a painting from a photo, you can license that.
Yep.
So that's always good to know that adaptations can be licensed, and it's better to do that than to get a claim.
That is so true, which are very expensive and unpleasant.
Next one. All right, so part of it is trying to defeat some of the myths that we hear all the time. And this is just a handful. You could call them copyright urban legends. So much of what we're going to say today will help explain why these are not true. So the internet is not the public domain, hence the title of our talk. And copyright notice is doesn't mean, the lack of copyright notice doesn't mean you can use a work without anyone's permission. And just the fact that you display it on a website and didn't make any money doesn't mean you didn't need to ask permission. And if you remove it right away, that's wonderful and good, and the thing you should do if it's not your image, but it doesn't mean there might not be damages for the amount of time it was up. And this one is my favorite. If I change it by 10%, I don't need permission, or fair use has no percentage of anything that makes something good. These are just things that get made up because no one likes that there's so much ambiguity about fair use.
I like to remind customers too, if you think it's a good idea to use the most iconic 3 to 5 seconds from a Rolling Stones song, Keith is coming for you with Mick. It's going to happen. Don't do it.
Yep. Can't always get what you want.
We didn't even plan that. That is great, Nancy. Good job.
Next. Okay, the other thing, copyright doesn't protect ideas. It doesn't protect systems, and it only protects works of humans. And sorry, Naru, I'm not sure if that's your name. The fact that you took your own selfie, you did not get protection. And the sculpture on the left was actually a sculpture, and they thought it was a work of art. But since it was used as a useful object, which are not protected, which is a bicycle rack, it lost its protection.
Whoops.
So as I was saying, that ideas and processes, facts are not protected. Titles and phrases are not, but they might have some trademark protection. Works have to be fixed to be protected, and works in the public domain, which we'll get to, are not protected. And as you saw by our monkey selfie, you need to be a human, which is going to be interesting when a lot of AI starts creating works as to where there's enough human element. Next interesting area. Oh, Heather, our other favorite area,
Tattoos. Yeah.
Like, at this point, you really can't take pictures of athletes without tattoos. And there is a lot of tattoo litigation. In fact, there's a lawyer I know that's been handling all these Take-Two games, and Take-Two wants to have very authentic avatars in their games. And so if a player has distinctive tattoos, they're going to show up as part of the game. Now, the courts have really been all over the place. There's this particular case, Solid Oaks, where they said that the tattoos, which are, even though it's on a body and not a
like standalone art.
Standalone art, it's not on a canvas, it's not on paper, it's still a visual work of art, and cases have confirmed that. So there has been an uptick in tattoo artists in suing. So in this case, the court found it was de minimis, and which means not enough of a copyright infringement. I guess the avatars, it was too, it wasn't visible enough, and so the case was dismissed. There's another case where the court couldn't make up its mind, and there's going to be a trial. And I think right now there is a trial on a third case. So this is an area for editorial use. Heather, maybe talk about that. You need to have authentic pictures, but if you're creating like a game, it's a little bit murky.
Yeah, and that's definitely something that comes up with customers too, where they think, oh, we're in love with this editorial photo and we're interested in using it on merchandise, or we're going to, make an ad campaign with it. Can you help us think through all the different elements? So if you're talking about sport content specifically, lots of layers. You got to clear things with the sports governing body, with the teams, with the players. Obviously, games like NBA 2K, they've thought through all of those particular elements with the people. But if there's any kind of, like trademarks going on, or perhaps these tattoos, and they're sort of front and center, it's definitely something that you'd want a rights and clearance person to help you think through. Somebody like Nancy can help you think through it. What could be the risk of using content that might feature that, unless you have specific permission from the artist. But it's a very interesting area, that definitely one to watch. Certainly something that we're sensitive about with our stock content that's available for commercial uses. You might have model releases from the models. If we saw content coming into Getty Images or iStock and somebody had a full sleeve of like Mickey Mouse, no, we're just not going to probably want to touch that. We don't think that our friends at Disney would like that very much, so we wouldn't have that. But other times models, the models that are being depicted there, they've actually created the artwork that they want tattooed on themselves. It's sort of a work for hire situation, working with the tattoo artist. But layers, I mean, Nancy, it's layers.
Yeah, there's this, we don't have time to do all the releases, but when you look at a photo, you have to look at what's inside the photo. Is there something that could be protected by copyright? Is there something that could be protected by trademark, like the team logos? And are there recognizable people or very unique property? So those are all these things you need to think about. Today we'll focus on copyright, which does include the tattoos, so it makes it
when we talk to customers, we talk about people, places, and things. It just seems to be an easy expression for them to remember.
Yeah. So, and here we have, idea versus expression. And what copyright doesn't do is give you a monopoly over an idea. So of course, there's all these photos in national parks that everyone wants to stand and get this special arch. And you will have similar pictures, but not one person can own that natural landscape. And no one can own the idea of taking a picture, for example, in a national park, or the idea of a particular pose, someone's arms crossed over them. So a lot of common poses, common subject matter, anyone can depict. And that's really the beauty of stock photography. You have lots of different variations of themes and ideas that people want to express, whether in business and health and many other situations. So copyright's not intended to give a monopoly, but you just have to do it in your own way. You can't copy someone else and make a duplicate.
I think, Nancy, you talked about a case in one of your books where there was a photographer who was well known for her style of shooting babies on a seamless white background.
Yes.
And yeah, and that was an interesting case that involved Tony Stone images. And I was working at Getty at the time that that case was being litigated. But in that instance, the judge was like, there's a baby on a white background. I don't know. And that particular case, in that instance, the judge found that that was not infringing on her copyright.
Right. And also the judge noted that it's kind of hard to pose a baby. They just sort of do what they do. So
yeah.
So things that are protectable, you know, the white background is an idea and not protectable.
Right.
Next, copyright notice. I mentioned we joined the Berne Convention in March 1st of 1989. It only been around for well over 100 years. But that was the time when copyright notice was no longer required on US works when a work was published. So a lot of older works are in the public domain by US authors, not foreign authors, because not everyone knew about that. It was sort of a trap for the unwary. If it's still a great thing to keep copyright in your metadata, and the proper way to do notice is the copyright symbol, the year, and your name. But if you do it wrong or you don't have it, you do not lose your copyright, which is important.
Right.
The length of copyright, how long does it last? Depends if you're pro copyright or not pro copyright. Some people think it's eternity, but the current act, it's life of the author plus 70 years. If the work is owned by a company, it would be 95 years for the corporation. It's because we had a whole different system under the act before 1978. We could do the next slide. That under the old act, it was a term of 28 years and a renewal term with many, many extensions. It is so complicated. I just keep this Cornell Library chart on my desktop. It is brilliant. It explains what may be in copyright, what may be out of copyright, what year, if it's published before 1964 with the copyright notice, but it's not renewed. I mean, it is so complicated. Just go with this chart or the rest of the hour will be spent on this.
It's a really well done site. I love it too.
Right. All right. Public domain is one of the questions you get all the time. Like, what does it mean? It doesn't mean that it's public. It really means a work is out of copyright. And in some instances, works are never in copyright. US government works are not protected by copyright, but that doesn't mean that the US government can't license a work and own it where the copyright owner still owns the work. Some states also have similar laws, not all of them, where if a work is created by a state government, it would be in the public domain. Right now in the US, if a work was published before 1927, it's definitely in the public domain. There's all this gray area of works published also before 1989 that may or may not have copyright notice properly, or works published before 1964, which might not have renewed, but, you know, completely sleep at night without any research, anything published before 1927 in the US. And remember, that's for US authors, not French, not Italian, not Spanish. And if you're a French author, you get this extra time if you served in the war. So you always have to look at the country where the author came from.
Right. And Nancy, just a comment, this comes up all the time. Customers get really confused about this. with this NASA photo specifically, this is Neil and Buzz, their, magical moment landing on the moon. Now, the photo, public domain, because it's a NASA photo, the people depicted still have a right of publicity that you have to think about.
Right.
Customers are like, but wait, they're government employees. They don't have rights. Yes, they do. They do. And they litigate those rights.
And
So you have to be careful.
Yeah, Buzz in particular notes that because the photo is so famous, he is recognizable because everyone knows that's him in that NASA
Right.
suit.
That visor,
So,
that visor shot, the famous visor shot. Yeah. Yeah.
Gotten so many of us caught. So.
Right. And just one more note too about public domain content. It's, the Copyright Library of Congress website, awesome place to go look for content that might be in the public domain. Read the fine print. Not, they will let you know if they know if it's something that has additional rights that you have to consider. National Archives, same thing. There's really great resources out there, but you still have to read the fine print and maybe do your research in addition.
And there's nothing illegal about using public domain work and enhancing them and relicensing them because it's your copy that you're licensing.
Yeah,
and as
you've
I
added
said
all that
before,
metadata, all the keywords. That was a lot of sweat equity that went into that for sure.
Just because you happen to find an image, for example, on a search engine's image search does not mean it's public domain because it's public. So the right-click license is not going to help you. You really need to look. One thing, just a footnote, is that if you go down into the more under Google now, you can actually find licensed content, which is really helpful.
Yeah, much better. Just a note too, like Washington, D.C. seems to be a place where everybody thinks that every building, every monument is public domain because it's Washington, D.C. and that's the nation's capital. And surely all of those things must be for the public and in the public domain. No, not true. There are definitely monuments. Even the National Cathedral is a private church. It's got a magnificent sculptural artwork going on inside. That artwork is protected. Some of the monuments are protected. You just have to really just do your homework before you do a photo shoot.
Next. All right. So once you have these exclusive rights, how can you license or allow someone else to use something? And it makes a difference whether you want to give exclusive rights to a third party or just a non-exclusive. Under the Copyright Act, any kind of exclusive transfer requires a writing so that would include an exclusive representation where you want to give someone rights to grant rights. Non-exclusive transfers do not have to be in writing, but we always like writings because, as they say, an oral agreement is only as good as the paper it's written on. Dun, dun, dun.
That's really true. Also, I like to say you need a permission slip for the field trip. That's a license. It's a permission slip.
Yep. And all right, so there's a lot of licenses available that do allow sharing. The Creative Commons is probably one of the most common one, though it's very complicated because there are some that only allow you to share if you give attribution. And there are photographers who have a lot of their images on Flickr sites and others that will allow sharing, but you have to give attribution. And if you don't, they will sue you for copyright infringement. There are some that make a living out of this.
Right.
Some can be non-commercial, some derivative. CC0 is similar to public domain. But you have to be careful with Creative Commons licenses because you don't actually know if the person who created the work is the one who attached the Creative Commons license on it. So I would recommend if you're a publisher, advertiser, user, that you use them without digging in a little bit because you really don't know if it's protective. You don't get model releases. And what you don't get, which most stock companies will provide, is sort of the ability to stand behind an image. You don't get contracts, you don't get an indemnification, you don't get reps and warranties, and you don't have any information about third-party clearance.
Right.
So I sort of look at the stock industry as sort of trusted licensing sources. And there's a really good example of what can go wrong, and I'll turn it over to Heather.
Nancy, this one is such a great cautionary tale for everybody. It's a great one for anybody who's considering sourcing content from a photo sharing website to consider putting it into, you know, a stock photo site situation to license it. It's a great narrative for customers who think Creative Commons is awesome, but they don't pay attention to what type of Creative Commons an image has. So in this instance, this teenage girl who's featured here, in both instances, she was photographed by, I think it was her pastor, her youth pastor, and this photo was shared up on Flickr. Well, Virgin Mobile, and I'm sure they were working with an ad agency, thought it was a great idea. You know, let's find some user-generated content from a photo sharing site. Let's not go with something stocky. No. Let's go with user-generated. And we're going to try to find somebody, oh, this girl would be great. We're going to use her in our Virgin Mobile campaign for dump your pen friend, use Virgin Mobile texting instead. She's making the V. This is going to be awesome. Now we're going to get a free copyright license. Yay us. It allows for commercial use. Awesome. We're going to move forward, but wait. There is an Adidas logo on her hat. We don't want that. Let's scrub that. Okay, now look how great it looks. Awesome. And that was put on bus shelters, sides of buses, and you know, this use went forward. Well, this young lady's friends saw this use and was like, are you a Virgin Mobile model? She's like, what? So they never thought through the right of publicity element. So of course the family, you know, she's 16, she did not sign a model release, and the family moved forward litigating with Virgin Mobile. Also double whammy because they didn't use the attribution for the Flickr photographer in the ad, which was a requirement under the Creative Commons license. They also had some litigation with the photographer. Now, can you call Flickr? Hey, Flickr, I got a claim. No, you cannot. There is no indemnification with Creative Commons. So Virgin Mobile was left on their own. And I like to think that Richard Branson maybe paid for her, you know, first 4 years of college and maybe bought her a condo. I don't know. I don't know what it settled for, but you got to pay attention. Use reputable sources, right, Nancy?
That's it. All right, and here's my favorite. Can't I just fair use it? Fair use is not a verb. You don't do it when you don't want to pay for something. Nothing is fair use. I get this all the time. I review a lot of documentary films, and everyone just loves fair use. It's newsworthy. Can't I fair use it? So let's explain and go on about how ambiguous fair use is. So fair use has been a part of our copyright law for years. It was based on case law and it was codified in 78 when we got our new act. But it isn't as if they gave us rules. Like in many places in Europe, you have very specific exceptions. You can do this, you can't do that. Other countries have something called fair dealing, which is a little narrower, but no, we get a balancing test. So no judges can figure out when it's really right or wrong. No lawyers can ever be really right or wrong because you never know. And everyone makes up fake rules about what's fair use and what's not. It's guidelines and not rules. And it's intended to allow for the use of content that's protected by copyright when the use serves a purpose that supports the Copyright Act. And so there's a list in the preamble of uses that could likely be fair use. It's not exclusive, but you have to really look at all the factors each time. So purpose of comment and criticism. No one's going to give you permission to critique their work. You want to have, you know, authentic film review, play review, book review. So you're going to have to use excerpts. You can't write a biography without using an excerpt. And you sometimes need examples of things in order to educate and teach people. And that's all considered fair use, but you have to look at each on a case-by-case basis. Yep. And you look at the case law for guidance, and the case law is always changing. So let's keep going. Here is the most recent case that will be actually argued next week. Next, on the 12th, we can all sit together at 10 a.m. and watch the Supreme Court hear the Andy Warhol Foundation case versus Lynn Goldsmith, the photographer. So these are some examples of some of the photos that were the basis of an Andy Warhol series on the artist known as Prince. And next slide. So this case went up and down. The facts of the case, and I'll try to do it briefly. is Lynn Goldsmith was asked to do a photo shoot of Prince. She did the shoot. It was for, I think, was it Vanity Fair? Vanity Fair. None of her photographs were used, but one was licensed to an artist who she claimed she didn't know who it was, which of course was Andy Warhol, who always did things in multiples. So they published one of his works, and apparently he had 16, which she didn't know about until Prince died. And one of the Warhol photographs was used in connection with an article of Prince, and Lynn Goldsmith said, hey, that looks like that came from my photo. This wasn't licensed. I licensed it years ago. She asked for money from the Warhol Foundation, because of course Warhol, this was taken in the 1980s, and Smith, and Prince, died fairly recently. And for whatever reason, maybe she demanded a lot of money. The Warhol Foundation filed a declaratory action saying that the Warhol paintings were a fair use of the photograph. And initially the district court, which is the trial court level, agreed. And they said that when you looked at the artwork, if you go back one, that Warhol sort of eliminated sort of all the creativity the photographer put in and really just kept, the facial features of Prince. Appeal to the Second Circuit. You can go two more. And the Second Circuit looked at the four factors and completely had the opposite opinion. They reversed the finding on fair use. They found it wasn't transformative. Instead of only seeing the Warholization, as they called it, of the painting, they said that you could still instantly recognize the underlying photograph, and they found that was not fair use. And now, for some reason, the Supreme Court has decided to accept certiorari in this case, an oral argument. The biggest concern we have, we being DMLA, is that the Supreme Court might come up with a definition of derivative. Remember, we talked about derivative and how you can license, like Lynn Goldsmith did, a photo to do an artwork, and where that line is between the fair use, where it's absolutely transformative and serves a different purpose, or it's just an adaptation. The lower court saw the market for Warhols as being different than the market for photographs. The Second Circuit found that there was a market for derivatives, and that was the market that was being harmed. Harm to the market is one of the factors. So next slide. And then we have memes all over the internet. And in many instances, copyright, unlike trademark, you don't have to enforce your copyright all the time in order to preserve it. But sometimes something can bother you so much that you are going to go after it. So the creator of Pepe the Frog did not like that his character was being used in connection with politics he didn't agree with. So he actually did bring a case. And here the court said this was not fair use. Of course, no matter how popular the character has become, you don't lose your copyright because something is so popular. And part of being a copyright owner is saying, no, I don't want you to use my work that way. So that's a good lesson.
Because you get to be bossy, Nancy, you get to be bossy.
Right. And so, of course, we have to look at factors, and I'll go through these. The purpose and character of the use. You look at whether it's commercial or nonprofit, but if we go to the next slide, this term transformative, which is not in the act, has become like super important. That's really what all the courts look at. And so you look, oh, does this use supplant the original by altering it and giving it new meaning? So when you critique or criticize something, you're adding new meaning to the underlying work. And so this has become the most significant question in all the recent cases involving fair use. It started many years ago, Campbell versus Acuff Rose, where Two Live Crew sampled Roy Orbison's Pretty Woman and made it kind of trashy. They asked for permission and were said no. So this is a good thing to note, that if you're told no, it doesn't mean it's necessarily not going to be a fair use. So they had really good lawyers, and they convinced the the lawyers for a Tu Lai Pru convinced the court that their song was really a parody on sort of the sacchariness and the sweetness of the pretty woman, and they were commenting on sort of their view of it from the street in a way. So the court never said it was a parody or not, but they did say parody was protected by fair use. And here's a great example of a parody, which is the Annie Leibovitz photo of Demi Moore that did get parodied by many magazines, and also became the movie poster for Naked Gun 33 1/3. And the court actually did find this was fair use and a parody, because with a parody, you have to take enough of the original to know that you're making fun of it. And again, that's because generally someone is not going to give you permission to make fun of their work. So parody has become an area which is permissible. And so the transformative doesn't replace these 4 factors, but it is something that you have to always consider when looking at a work, whether a court may lean toward fair use or not. And we'll see. Everyone tune in on Tuesday.
Right.
The nature of the work, factual or creative. So there's the purpose of copyright is fostered where you protect highly creative works more than factual, because you don't want to give a monopoly to facts. Now we go on to number 3. Ba-bum. Okay, how much did you take in relation to the whole? Well, with photos, mostly you have to take the whole thing, because otherwise, you're not making your point. So in many cases, courts have allowed taking the whole thing a photograph. With audiovisual works, that's another issue. And often you look at, well, did you take the heart of the work? Did you take what's so important? And one of the early cases involved a book. It was a biography of Richard Ford, and the only reason anyone thought he was interesting at all is because he pardoned Nixon. And so when the portion of the book was scooped that talked about that, there was a lawsuit, because it was basically, that's a heart of the work. No one would care about anything but that. And
one comment I can think of for the substantiality element, we've definitely seen our share of claims from designer furniture makers, like French ones specifically. And even if you use just a portion of the chrome frame on a chair or a couch, and the whole piece of furniture is not in view, and a certain fondation in France finds it, that is enough. That is substantial enough to them. And so
bring up something really interesting. Furniture is not protected in the US, but it is protected in France.
Right.
And so the US has all this wonderful knockoff chrome furniture, design out of reach. No. And you really can't take a shoot of a modern office without some kind of modern looking furniture. And it's really challenging, because they think everything's adapted from their designs. So it's really challenging.
Tricky.
Modern furniture. Okay, the 4th factor, once the most important, it's eking its way back up. But the effect of the potential market for, or the value of the copyrighted work. And here, as an example, in the Warhol case, if you look at the market for fine art, Warhol and Lynn Goldsmith were not in the same league. However, when you look at the market for licensing derivative works, that was the market the court looked at. And so what's in the market is very interesting. And that was a really big issue in the Caro Prince case, a case that came in New York, where the appropriation order, Richard Prince, not the musician Prince, found a book that a photographer, Caro, had done in Jamaica, where he probably spent like 6 years in Jamaica, building up relationships and trust with Jamaicans. And he did a beautiful black and white photo book. And Prince picked up this book and said, oh, I really like these, and did an entire show where he adapted and modified like all 34 or something of Caro's works. Now, some were very collage-like and didn't retain a lot of the photos, and some were much more based on the original photographs. And actually, when Caro wanted to do an exhibition, the gallery who was going to give him one said, hey, we're not giving you one because there's already, Prince is having his exhibition. So this is a situation where the lower court said it's absolutely infringing. On appeal, the court said that many of them were fair use, and it didn't matter the intent of the artist. It was really the perception of the viewer, which was interesting. And they looked at the market for Richard Prince's work, which was like $1 million, versus the market for fine art photography. And they looked at them as two different markets, which is very different than in the Warhol case. But they found these collage style ones to be fair use as a matter of law. So that's like 3 appellate judges, being art critics. And there was another handful of them that were more like the lozenges on the guitar. And those they could not determine as a matter of law. And there was going to be a trial and send back to the judge who thought they were all infringing. So the case settled, which is what happens if you can't get rid of a case generally on summary judgment without a trial. Cases will tend to settle. And judges, and I'm going to run through a whole bunch of cases where you can see how confusing it is, because sometimes judges think it's obviously fair use, and sometimes they think they can't make a decision on it and they'll let a jury decide. And that's typically when it's too expensive and no trial. So for example, celebrities are always posting pictures of themselves on Instagram, and photographers are consistently these days finding these photographs using technology, image recognition, and bringing claims against the celebrities of whom the pictures they took are at. And usually it's paparazzis who these models or celebrities don't really care for. So in this one, she saw the paparazzi taking pictures and she put flowers in front of her face. The paparazzi sued, and the courts, and she claimed it was fair use because the idea of her putting the flowers in her face was commentary on what she thought about her picture being taken, essentially. And the court actually found there was triable issues of fact about harm to the market. So this is a case that the court couldn't decide either way was fair use or not. Next slide. And here we have an example of outside mural art, which was this, I think it's Obey, and the band Green Day used this iconic work of this outdoor artist as the backdrop for one of their songs. And all they did really was put a red cross in front of it. And the court allowed it under fair use because they found that it was transformative, that there was a relationship between the song and the music, and it wasn't being used for merchandise and anything commercial. This decision was appealed and it was affirmed. So as you can see, knowing whether something's fair use or not can be a little tricky. Next slide. Now, this is an example where entire images were found to be fair use because they were put in a historical context. So there was a collector archive that saved music posters and had all the Grateful Dead posters, and a biography is being published on the Grateful Dead, and they wanted to license the posters and they asked for too much money. So they used them anyway, but it was small thumbnails in a timeline with a lot of context around it. And the court said it was transformative, even though the entire photo was used, because they were placed in a historical context and they weren't being used, essentially like for their aesthetic appeal. It wasn't like a coffee table book of just posters. So they weren't exploiting the expressive value of the images. And they found that there would be no harm to sale of the original works. And they didn't even look at harm to the market for licensing. And of course, then we get into the area of news reporting. And this is also a very confusing area. Is an image being used because it's the news itself, or is it just illustrating the news? The licensing of editorial images is based on the fact that images, when they illustrate the news, give you so much more information that there's a lot of value to them. The preamble of fair use talks about news. So where is the line between when you can use something and when you need to license it? And it's a little subtle. Now here is an interesting one, because there was a wedding at one of President Donald Trump's golf courses at the time, and he came by and surprised the guests. One of the guests named Otto took a picture on his iPhone of Trump, and he texted to his friend. Well, his friend ended up, I believe, like licensing it to some media outlet, which was the Hearst Communications
I
Company.
think she posted it to social media, and then
That's
the news
right.
outlets picked up that
Yes,
how viral
yes.
that post went.
Right. It became viral. News media picked it up, and they sort of picked up a story, and it became a viral story about how, the president showed up to this wedding. So the photographer sued Hearst, and Hearst brought up the fair use defense, saying that the idea that Trump would show up at a wedding was so newsworthy that it should have been a the fair use defense should apply. The court looked at the defense and they determined that it was a commercial use, which weighed against a finding of fair use because Hearst received advertising revenue. And the photograph nature of the work was kind of neutral because it was sort of factual. But in the end, the court concluded that it really did weigh against a finding of fair use. So they actually had a trial on damages, and you know what the photographer got? The minimum statutory damages, $750. So that's also a cautionary tale that you should try to settle these cases even as the plaintiff, the photographer, because statutory damages are discretionary with the court. It probably licensed for a few $100s, so it goes from $750 to $30,000. And only can be enhanced if it's willful. So there's no guarantee that you're going to get the top end whenever you bring a case.
Yeah, and litigation's just time consuming and expensive.
And next slide. So I don't have the actual picture that this was a case, but this was this case that took place in a newspaper in the District of Puerto Rico was one of the first examples of where a photo itself was the news and actually did qualify as fair use, but it is sort of rare because in that case, there was the fact that the photo even existed became newsworthy because it was a picture of a person who had been willing, I guess, to pose nude for a photographer. And that the fact that those pictures existed became a political controversy. So the photo itself was the subject of the news and the fact that it existed. And so, I mean, that's already very early days, 2000. So that is an example of where the picture is the news itself, and it's not just illustrating the news.
Nancy, just in the interest of time, I think we have
Yes.
about 10 minutes left, and I know we still want to get to some questions.
Oh, yes.
So I'm going to just very gently click, and then you tell me where you want me to
Okay.
stop in case you want to
Okay, I'll
make a
do a
point.
very brief one on the one where they're kissing, because it's the
Oh, okay.
opposite example of the one we just talked about. They here is a magazine took a picture of an actress who had a secret marriage. Chauffeur sold the pictures. They ran a big spread, and they said, well, it's so newsworthy that she had the secret marriage. And they said, well, you could have published that without the pictures illustrative. Okay, let's move. Yeah, we have lots of fair use examples. Let's move through them. Unless there's one. Oh, Pillpot, I'll just stop 1 second here.
Okay, sure.
This is the guy who puts his images up with attribution only and will sue if you don't use attribution. So, okay.
Read the fine print.
Yeah, and this is an example of a case where they were using an image just to illustrate the geographic location of where they had this festival. That was not transformative. So let's maybe a minute on linking. Linking has become a really controversial issue because the courts are very uneven. So the whole concept with Google image search is that images are embedded and they're never on the server, but they're just pulled up and framed from the source server. The Ninth Circuit has found that what's called inline linking is not infringing, and that was believed to be sacrosanct, and no one contested it until recently. And next slide. And a lot of when in the Southern District of New York, there started to be cases about whether the embedding of a photograph where you don't even know where the source came from was infringing or not. And so the first judge in the Goldman versus Breitbart case said that she wasn't going to follow sort of the server test of perfect 10. And embedding wasn't automatically immune. You might have other defenses, but not automatically immune. which has come to an issue because a lot of publishers had been using a service that was offered by Instagram, where you could use an app from Instagram, and it said, use the app for storytelling and will automatically give attribution. And courts in New York have found that they're not following the server test. So that's called a split in the circuit. So it's very hard to give advice. The issue is your exclusive right to display violated by having the frame and link, even though it's not sitting there. So this is an area we're keeping an eye on, and this is why it's always easier and more advised at this point, particularly if on the New York coast versus the California side of the coast, to license where possible and not embed unless you're writing actually about the photograph. So let's go. And we'll keep going, because we just talked about that. It's another New York case where courts have found it violates the display rights. So that's been Nicklin and McGuckin.
This polar bear, Nancy.
It makes me
Oh,
sad. Yes.
I know.
So maybe we'll spend 1 minute to say, like, what is copyright infringement? That's where you have violated one of those exclusive rights we described. You can do it by actually copying, or which obviously means you have access if you copied the original, or if you recreate an image so it's so close to the one you're copying. And that's called substantial similarity. What is substantial similarity? Well, you put images side by side, and basically your stomach tells you if you think it's too similar or not. No, we'll see what you really look at. The gut test. Next slide. So here, this is an example of a case that went on where the issue of what was substantially similar, and the court came out and saying that you can't really own a pose. And they found that these, even though it was both Michael Jordan doing his split air jump, there was enough differences in the pose and in the backgrounds, the mood, the time of day, the lighting, the composition, that they were not substantially similar. And these are
Speaking of which, you have all them listed out right here.
Yes, so these are the things that courts can look at: posing, perspective, lighting, shading, angle, color, background, and viewpoint, which you still have even when you use an iPhone. And so if you infringe, these are things you can ask for. Damages, statutory damages, you only can get them if you registered in time. That's a whole nother 1 hour lesson. These are the amounts of statutory damages. And also attorney's fees are not automatic, even though you read you can get them. In Southern District, New York, pretty tough. So never think it's automatic. And there's some great news on the horizon. We have a copyright small claims court. We've been working on this for over 10 years. And you can actually, if you have a case where the value may not be substantially high, to spend lots of money on lawyers, you can actually bring a claim with the copyright small claims part of the Copyright Office. And the filing fee only starts at 40, then goes up to 60, and you don't need a lawyer. You can bring one, but you don't need one. And it's supposed to be streamlined and simple. It started this July, and we're checking to see how well it works. And Heather, to you.
I just had a note about programmatic enforcement. There are photographers that are out there that are using different, devices to look for instances where their content may have been used without their knowledge or permission. And sometimes with those programs, you get a really interesting match like this one, and you pursue it. Maybe you're not properly vetting the comparison between what was found, but just note to self, like, you definitely need to do your due diligence, make sure that that content is a true match. Think through, is it shot from a very unique perspective? It's the only way that you can shoot that photo of a certain natural vista, or a certain, it's the only way to get a certain shot, a skyline shot of New York, for example. And then licensing visibility, that can get really murky, especially with royalty-free licensing. It's hard to know if the end user has a license through an agency. And just what the terms of that license actually are. There is information that's always provided on a royalty statement, but sometimes there's a lot of nuance that goes into how customized that license is. And before you pursue something, just make sure that you are fully informed with the facts before going out guns blazing. Fair use in public domain. Definitely, if you need to phone a friend with Nancy and maybe do a fair use analysis before you send that threatening, expensive, potentially product eroding, letter out to an end user. Think through that. Also, make sure that if you are somebody like, Getty Images, where content's coming in, maybe it's coming in and it's public domain. Public domain content is not a good idea. Nancy knows it's just not a good idea for programmatic copyright enforcement pursuit. It's
Never
never.
do it.
Yeah. And then also there's a really great guide on DMLA's site about best practices for copyright enforcement. And this is going to be a super hot topic at the conference. So definitely attend. Okay, I'm going to stop sharing, Nancy. I think we have 3 minutes. Has anybody been watching the chat?
Yes.
Yes.
So thank you so much. Excellent. And I'm just going to repeat some questions from the chat. Feel free to put them in. So we have Emily Teresa asked if an artist created art before 1927 but dies much later and they have an estate to control the artist's work, do we still need to clear permission from the estate for the artwork before 1927?
Okay, good question. Okay, first, is it a US author? And 2, is the work considered published or not? And with artwork, you have to look at the definition of published in the Copyright Act. Usually it's the offer to sell or offer to make other copies. If you just display something on a wall, it may not be considered published if it's not offered for sale. So if a work is published before 1927, it's in the public domain. The fact that the artist died after 1927 doesn't matter for that. You have to look at when the work was published. That's for US authors. For works that would have longer duration, you look at 70 years after the author's death. And there's a lot of gray in the middle. Look at the Cornell chart.
So the next one, with education fair use, does the user need to get permission, give attribution, or both?
Okay, attribution is not part of our Copyright Act, believe it or not. It's required if you write a paper in school. You cannot not give attribution because that's ethical, but it's not part of our US Copyright Act. With education use, you need to be, it's not there to illustrate something educational. It's there when it's an example and they're teaching something about what you're looking at. It doesn't mean that because an image is in a textbook, it's educational. It's really when the work itself is educational, copyright laws vary from country to country. Okay, the ownership of copyright is the nationality and the domicile of the author. So if you are a French artist and you created work in France, whether you own the work, you look at French law. If the work is being infringed in the US, we will allow that case for infringement to take place in the US because the infringing activity took place. So it's always different. Ownership is country and infringing activity is in the country where the activity occurred. And generally you only can bring claims for infringing activity in the US and not for claims that are outside the US. And the same is are you a US author or not? There's a definition in the Copyright Act, and the work has to be first published generally in the US, and you have to be a US national or domicile, or you have to be US national and domiciled. So again, if you're a French artist, the work is first protected and is first published in France. You are not a US author. That's important because US authors have to have a copyright registration in order to go to court. So even you go to Copyright Small Claims Court, you need a registration. You can get that registration the same time you file your claim now, which is something great. But if you're a US author, you don't have the keys to the courthouse without a registration. Even if you're not entitled to statutory damages, you still need a registration. If you're a foreign author, you can go to court without a registration, but you cannot get statutory damages or attorney's fees.
Any final questions? We're basically at time here, but yeah, we thank you so much for coming out. Thank you to Heather and to Nancy for sharing your expertise.
And I have to thank Heather. She put all those amazing pictures in these slides, and thank Getty Images for letting us use them.
Snaps.
I could never have done anything like that. That was great. So thank you. I
3
wanted
cheers for
to
great
do a
content.
shout out to the images.
Absolutely.
Thank
And
you.
just to remember, this is just one of the many educational opportunities we have at DMLA. I'm going to put right now the link to our conference, which is coming up in just a few weeks. If you haven't registered, now's the time. Get your ticket. We have one of the best programs ever, including Shira Perlmutter, who is the Register of Copyright, the Director of Copyright for the entire United States. Will be giving an exclusive talk. We also will have Nancy and I believe Heather as well, and others coming back to talk a lot more about specific topics, and particularly about things like the Case Act and other kinds of in-depth copyright topics. So please do remember to get your ticket. Time's running out. Go ahead and do that. And thank you for joining us for our Info Plus webinar series. Again, thank you to the speakers as well.
Thank you.
Thank you for having us.
Have a great weekend.
Bye.
Bye.